Thank you, first of all, for the organizers. It's been intriguing so far, and I'm sure it's going to be very interesting. I'm very excited to be here and to learn of this project of South to South. What I'm going to present before you today is part of a larger project that I'm working on, which focuses on what I call required intimacy. Sandy mentioned in her talk earlier today the problems of intimacy, and I want to go deeper into this analysis and talk about this notion. I believe that the way we regulate intimacy is crucial for understanding disadvantage in today's labor market, especially once it's consumer-oriented and a service market, and consumers expect intimate behaviors on many levels from service providers. So required intimacy is when intimacy, in one of more three forms that I will present in a bit, is part of the job requirement and is demanded from workers. I believe that in today's labor market, required intimacy is one of the main challenges in placing women, many of whom experience intersection with race and poverty, in a social and economic disadvantage, and also in a more subordinated situation. One of the groups experiencing the problems of required intimacy in one of its most extreme forms is domestic workers. Actually, the extremeness of required intimacy in their work leads to situations where autonomy has been diminished, therefore being, so I believe, forceful in essence. The prominence of required intimacy in today's labor market requires from us further rigorous thought, and I call for all of us to do more work on this issue. So what I'm going to do in my presentation today is discuss the notion of required intimacy, its social and economic effects, as well as its strengthening of women's subordination. Then I will use the example of domestic workers to show how required intimacy can lead us to extreme situations of forcefulness. What do I mean by required intimacy? As I said earlier, required intimacy is when intimacy, in one of more or three forms, is part of the job requirement and is demanded from workers. These three forms are, first, performed intimacy. By performed intimacy, I mean activities conducted by workers during the course of their work that include exposure to or physical contact with another person's body or intimate habits. These activities comprise of bathing, dressing, feeding, massage work, hairdressing, etc. The second form of intimacy is emotional intimacy. Now, psychological scholarship considers emotional intimacy to be more substantial to the individual than other forms of intimacy, including romantic intimacy and sexual intimacy. In order for emotional intimacy to occur, there has to be an exposure of one person to another, while there's a receiving of an empathetic and understanding reaction from that other. Domestic workers are often obliged to act in emotions toward the people they care for, thus creating emotional intimacy between the two parties. Hairdressers have emotional intimacy at times with their clients. Teachers create emotional intimacy with some of their students, nurses with their patients, etc. Even bartenders are seen as the wailing wall of returning customers, having with them emotional intimacy. Now, the third form of intimacy is sexual intimacy. There is a blurring line between performed intimacy and sexual intimacy, since many chores involve touch and exposure to intimate organs of the body. Such contact in itself creates a form of sexual intimacy. However, sexual intimacy includes further dimensions than these, like sexual humiliation, assault, and physical oppression. Just from the introduction of these three forms of intimacy, one can think of numerous work positions in the market today which include at least one of them. Now, how does the law regulate intimacy? The law, in all these jobs, shapes the demand for intimacy as required. Labor laws based on the idea of freedom of contract provide managerial prerogative to employers to define job requirements, including requirements for intimate behaviors, which the worker can accept, decline, or theoretically bargain. Once accepting the job, the worker is obliged to perform what has been agreed upon according to the contract. If she is not pleased with the requirements, the law provides a way out by means of resignation. Workers' decision to accept, decline, or negotiate is seen as an expression of their autonomy. Exercise of the right to resign is also an autonomous expression in labor law. This framework is based on a liberal perception of the contract and of the individual, whereby the individual expresses her own wishes on a free and equal basis through the choices she makes regarding the contract. Now, this liberal perspective has been challenged in the field of labor law, and scholars have shown its limitations, especially in respect of women and migrants whose social, economic, and legal situation denies them from being free and equal. Women and migrant workers exhibit further disadvantage due to what has been termed the gender contract and migration controls, having minimal ability to accept the terms and conditions of work, to negotiate, or to resign. However, this liberal perception still applies to job definitions. For example, job requirements may include the provision of sex for pay, as they do in the sex industry. No limitations or boundaries exist in this regard, apart from court's refusal to view the arrangement as a contract of employment on the basis of illegality. Additionally, international human rights laws, equality laws, and labor protective legislation place no limitations on intimacy unless it falls into situations of sexual harassment, rape, or other sexual assaults. Now, one might ask, why is the requirement of intimacy different from other job requirements in the market that are too part of the employer's prerogative and are not prohibited by law? And I believe there are a few characteristics of intimate work that distinguish between jobs that require intimacy and other job requirements. First of all, intimate work carries with it emotional burdens on workers. It has implication on a person's well-being and emotional state. Arlie Hochschild has titled this as emotional labor. A mere evidence of emotional labor is distancing practices that have been adopted by workers in order to distance themselves from these situations. Also, intimate work is undervalued. It is seen as something that is a natural gift of human beings, not as skilled work, and not as productive work. There is, of course, a gender dimension here due to the undervaluations of women's skills, which is very much related to all three forms of intimacy that I presented above. Intimacy is also seen as located in the realm of the private and not the public spheres. And thus, when intimacy is found in work relations, these work relations are viewed more personal than more bureaucratic forms of work. This is the case of domestic workers, which I will discuss in a few minutes. And moreover, because intimate acts are seen as private, it is very difficult to assess when they are part of the job and when they are not, or in other words, when a person is working and when she is not. Fourthly, the requirement of intimacy at work is usually towards a customer, a client, someone receiving the service. A teacher is required to be intimate toward her student, not her employer, so as the nurse, the bartender, the masseuse, etc. Here, the interaction with the service receiver is highly significant, but it is rarely regulated by labor laws or by other fields of law. Rather, it is seen through the prism of consumer rights and protections. Now, consumer rights and protections, too, strengthen the perception of intimacy as required. These characteristics place people whose work involves intimacy that is required in an economic and social disadvantage. Moreover, as I want to show you, to discuss now, it strengthened the perception of women as inferior, and mainly women who are conducting this work who are predominantly migrants and poor. Let me explain this by discussing the theory of objectification. So the core idea of objectification is denial of autonomy. And as I just explained, this is what required intimacy is all about. Denying the autonomy of the worker to decide whether she wishes or not to engage in intimate activities. But we can see also other notions of objectification in the situation of required intimacy. One of them is denial of subjectivity. Now, Martha Nussbaum has noted this as one of 7 notions comprising the idea of an object. Denial of subjectivity means that the objectifiers treat the object as something whose experience and feelings, if any, need not be taken into account. Seeing intimacy as required means that no weight is given to the emotional implications intimacy has on workers, and thus their feelings are not taken at all into account. 2 additional notions of an object that Nussbaum mentions are relevant as well. These are, first of all, instrumentality, when the objectifier treats the object as a tool for his or her purposes, and innerness, where the objectifier treats the object as lacking in agency and perhaps also in activity. In most jobs where intimacy is required, the worker has no agency to decide her own tasks, which are determined by others. We know this is true in respect of domestic workers, cleaning, hairdressing, lap dancing. It's all there. Now, the troubling thing about objectification is not necessarily its mere existence. This is because objectification in itself is not necessarily bad. There are some good things to objectification, like earning a salary, and the receiving of intimacy by recipients. I think that we are a society that wants intimate behaviors. The more troubling thing about objectification is its epistemological dimension, something that Ria Langton has highlighted in her work. The epistemological dimension is more than treating a human being as an object, which is what Nussbaum's work focuses on. It means to see something that has been objectified as the real thing, as the objective truth. Hence, intimacy is viewed as required, and this becomes an objective truth by society, which does not doubt it, think of it, or debate it. Moreover, it is something that society strives for, and by doing so, it places those performing acts of intimacy at work in a subordinate position. I will explain this by giving an example Ria Langton herself discusses, which is pornography. Pornography has a significant role in shaping desires. Pornography can shape sexual desire, which is violent. The desire then becomes the driving force of someone's hopes, wishes, and afterwards actions. Pornography also provides evidence to strengthen a certain belief. It can strengthen a belief that women are inferior to men, that they enjoy violence and even rape. In this way, the desire leading our dreams and hopes about sex helps to make the object be inferior. Now, in exactly the same way, we can think about required intimacy. The fulfillment of intimacy by a worker becomes the desires and hopes of the employer and the person's receiving the intimate behavior. Even the lawmakers, as I will just elaborate in a bit, see it in this way without questioning this perception of intimacy. So the epistemological dimension affects the way we view women in society, as a group that chooses jobs that entail intimacy, as those who enjoy it, as people who wish to provide unlimited intimacy to others without hesitation. In this process, women become more subordinated. Now, once these perceptions have become part of society, and they have become a very central part in our service-oriented society, then it's much easier to see attempts made by lawmakers to push further demands for provision of unlimited intimacy by workers to its full extent. Now, the epistemological level that I just described raises many concerns, but what I want to focus on in my discussion on domestic workers is the pushing of the provision of unlimited intimacy to its full extent. And I use this framework to analyze the situation of domestic workers, revealing that their situation should be seen, so I believe, more as a situation of forced labor than as a situation where their rights are infringed. Now, it's not that the situations that I'm going to describe now are seen or are captured by the term forced labor that is adopted by the ILO and other countries, but it has strong forceful elements in it, which this idea of required intimacy helps to shed out. In my reading of reasons given to legal decisions regarding domestic workers, the cause of required intimacy legitimizes four forceful situations. The forcing, I see that I'm not, okay. The forcing of working time and of space, the forcing of intimacy, the forcing of economic disadvantage, and the forcing of specific employers. Now let me explain how policy pushes towards these four situations by using required intimacy as a cause in the decision-making process. And I will talk about Israel and Britain particularly. So I'll start with the forcing of time and space. In both Britain and in Israel, it is unquestionable that someone can be a live-in another person's household. this has become an absolute truth. The fact, however, that a domestic lives in the family household does not necessarily imply that she does not deserve a time of her own or that she is not entitled to her own space beyond the walls of the house. We heard this morning about the Brazilian regulation, which might be very interesting in this respect, and I would love to learn more about it. But theoretically and practically, we can distinguish between the idea of live-in and the autonomy of space and of time, at least to some extent. However, both in Israel and in Britain, the law denies such autonomy. Following the European Working Time Directive, Britain's working time regulation exclude domestic workers from their scope. In Israel, too, the Supreme Court decided 3 years ago in a case called Gluten that the Hours of Work Act does not apply to live-in domestic workers. One of the main reasons stated for this availability of performed intimacy, as well as emotional intimacy, 24 hours a day. This comes very strongly from the case law, that the worker is required to give her intimacy 24 hours. Some of the judges even say that the worker is like a family member, having substantial emotional relations with the family and the care receiver. Now, the second thing that I want to point out is the forcing of intimacy. In Israel's policy, domestic workers are denied to come into the country with a family, a spouse, or children. However, a question emerged regarding the right of a domestic worker to give birth while she is in the country. The Israeli Supreme Court decided that a domestic worker has family rights, declaring that a policy stating that domestic workers have to leave Israel after giving birth is unconstitutional. However, the court at the same time said another thing, that the worker can stay in Israel with the child only if she provides the best possible care to the care receiver, thereby placing the care receiver in a more preferable situation than the worker's own child. The reasoning given is that the worker came to Israel to work and not for some other purpose, and therefore that her obligation is first and foremost to her care receiver. Given that most domestic workers are live-ins, there is no substantial meaning to the family right given to them, except for the right to give birth. In practice, what this decision does is not only prioritize intimate relations with the care receiver over the intimate relations with a child, but it essentially forces intimacy on the domestic worker with the care receiver alone, because she has to be there 24 hours a day, almost 7 days a week. Another thing that happens is the forcing of economic disadvantage. In Israel, workers working extra hours receive more pay. The Supreme Court's decision regarding the non-application of the Hours of Work Act to domestic workers denies them such economic rights. Therefore, workers working long hours every day and night are entitled to receive the minimum wage alone, and some of them don't receive that too. The reasoning given for not granting domestic workers extra pay for extra work is the weakness of their employers, who are also from disadvantaged groups. These can be the elderly, the disabled, and of course women who go out to work. They, the court said, could not afford to pay extra hours. Now, this decision has to be assessed with Israel's welfare policy as the backdrop. According to this policy, the elderly and disabled are better off when staying at home when they're institutionalized. There is a privatization of the service, as well as the privatization of care that women have to pay for. And hence, there's a preference of personal care and intimacy to provide within the family, while at the same time seeing them as not having the financial means to pay for such care. And then this makes domestic workers, they're forced to be economically disadvantaged in comparison to other workers in the market. The fourth form of forcefulness that we find is the forcing of specific employers. In both Israel and Britain, domestic workers are bound to some extent to a particular employer, thus denying the right to leave their job or stand for their working rights, because if they do so, they find themselves in a situation of illegality. The binding of domestic workers to the employers is part of Britain's new visa scheme, and it also applied in Israel until the Supreme Court declared this policy to be unconstitutional in a decision given in 2006 called Kav La'oved. However, the interesting thing is what happened after this decision, and it happened only in the domestic care sector. Following this decision, employers started complaining that workers tend to leave them, and the Israeli legislature made changes to immigration rules. According to these changes, domestic workers' movement is restricted within a specific area, and they're also entitled to change employers only 3 times during their period of stay. The reasons given for this legislative amendment is the dependency created between the care receiver and the domestic worker that makes it extremely difficult for the care receiver to adjust to a new domestic worker. Thus, the consideration of the intimate relationship has been used as a cause for the forcing of specific employers to this group of workers. So to conclude, in all these examples, I have shown that the need for intimacy has been used as a reason for regulatory decision. The idea that intimacy should be required from workers has not been questioned nor debated. Rather, it has been pushed to its extreme extent, denying workers their autonomy and eventually placing them in forceful situations. The prices of required intimacy that I presented earlier have not been considered. Now, I don't think it's accurate to say that the outcome is an infringement of rights. Rather, I believe that it falls into a spectrum of forced labor. My argument is that an understanding of required intimacy through the viewpoint I'm offering here should lead us to think, to place limitations on intimacy in work relations. Such limitations can be achieved in various ways. First, through the adoption of labor laws that limit the extent of intimate work, like working time regulation and its application on all works that require intimacy. Second, by health and safety regulation. Now, this entails a broad thinking of health and safety regulation, letting inspectors in, but also recognizing the emotional implications and all the other implications that intimacy has on workers when we define what is a health and safety risk. We can also use ethical codes of conduct, like the ethical codes of conduct the doctors have, that regulates in some forms acts of intimacy between the doctor and the client. We can use these ethical codes of conduct also to regulate other jobs that involve intimacy. We can use administrative orders, and also we can find employers responsible to limit the intimacy that they require from their workers. This is, of course, not the case in most cases of required intimacy that we find today. So I therefore believe that our task in the near future is to think rigorously on required intimacy. This is not something that is going to fade away. In a consumer-oriented society and work domain, and when we expect intimate behavior as customers from workers, this puts us as a main task for future work. Thank you.